Welcome to Face the Jury, the podcast dedicated to confronting the issues of medical malpractice in America, what it is, how to spot it, and how to protect you and your family from medical negligence. I'm your host, Lloyd Bell, a medical malpractice trial lawyer representing people who've been harmed by medical negligence. For more information, visit us at belllawfirm.com. This episode of Face the Jury is brought to you by our friends at Hughesby Reporting, the nationwide leader in court reporting, videography, and trial services. Visit hughesby.com for more information. That's HUSEBY.com. We've heard a lot of commentary recently about who is the GOAT of professional football. GOAT meaning the greatest of all time. Is it Tom Brady, Joe Montana, Drew Brees? Well, we are fortunate to have with us today one of the GOATs of medical malpractice trial lawyers. Our guest today is a leading patient safety advocate and attorney who represents seriously injured people in lawsuits against hospitals, doctors, drug manufacturers, insurance companies, and other corporations. Our guest today practices trial law in Washington, D.C., and has achieved amazing results for his clients over a career now spanning 4 decades. But the mark of a truly great trial lawyer is not just the ability to succeed in the courtroom, it's a desire to teach other, less experienced trial lawyers how to succeed for their clients. And our guest has made an enormous impact on the practice of law by co-authoring, along with another great trial lawyer, our friend Rick Friedman, what I consider the most important book on plaintiff's trial practice. It's called Rules of the Road, a Plaintiff's Lawyer's Guide to Proving Liability, published by Trial Guides in 2006. Since then, the techniques that are described in the book have been the subject of national and regional seminars for trial lawyers, sponsored by the AAJ, American Association for Justice, which is the largest organization of plaintiffs' lawyers in the United States. In 2012, our guest was the lead author of a follow-up book, another great book called Winning Medical Malpractice Cases with the Rules of the Road Technique. He co-authored the book, The Fearless Cross-Examiner, Win the Witness, Win the Case. This book aimed to overturn standard advice on how trial lawyers should conduct cross-examination and instead advocated a more analytic and adaptable approach. Before attending law school, our guest was a medical writer and investigative reporter for the Miami Herald. He was a finalist for a 1980 Pulitzer Prize for Dangerous Doctors, a series of articles that he co-authored identifying the problems of medical malpractice. He earned his JD from Yale Law School in 1984. He was a law clerk to Judge Gerald Gessel of the U.S. District Court for the District of Columbia in the mid-'80s. Judge Gessel was famous for presiding over the Watergate trials and later the Iran-Contra trial. After clerking for Judge Gessel, our guest worked for 22 years for the law firm now known as Stein, Mitchell, Muse, and Cipollone. Our guest has received just about every honor and award there is for trial advocacy. He is a longtime member of the Inner Circle of Advocates, an accomplished amateur photographer, and an all-around Renaissance man. And it is my pleasure to welcome to this show, Mr. Patrick Malone.
Well,
Pat,
thank
welcome.
you, Lloyd. Hey, I barely recognize myself, but I guess I'm in there somewhere.
Well, the hardest part of that introduction was the editing, because I could have gone on for another hour and not given you a chance to talk. But I really appreciate you being here with us today,
Sure.
Pat, and sharing some of your wisdom and experience as a trial lawyer and a teacher and just an all around great guy. So thanks for being here.
Sure, glad to do it.
So when I was preparing my show notes and thinking about some of the things that would be interesting to our audience, recognizing that this podcast is focused primarily on issues of medical malpractice. There's so many aspects of your background that I find interesting. The first one is your education. You're a Yale Law School graduate. When I think of Yale, I think of Supreme Court justices and big law and New York City ivory towers. We don't necessarily think of a trial lawyer in the trenches, in the courtroom, talking to juries. So tell us how this happened. How does a Yale man end up dedicating his career to helping patients?
Well, I kind of ended up at Yale as a matter of luck and good fortune. I think they accepted me because I looked a little bit different than the typical overachieving high LSAT recent undergraduate person. And instead, I had spent 9 years in journalism. As you mentioned, I was at the Miami Herald, and before that, I was at United Press International. And so I was kind of down there already in the trenches trying to talk to regular people, explain complex stuff because I focused on medicine and the healthcare system. And so I was kind of primed to be more of a people's lawyer. And then getting into Yale, I discovered very happily that Yale at that time had and still does have a very strong clinical program advocating for people. They had a prisoners legal project for habeas work and prison conditions litigation. They had a family law clinic, which I was also part of. I actually argued a case in the Second Circuit when I was a law student that wound up as a reported decision about the rights of foster parents. They used to take foster children very arbitrarily out of foster homes. It would just break your heart to read the facts of some of these cases and talk to the clients. And we were able to establish a little modicum of due process for those folks, the foster parents who had fallen in love with their children, which is something that the social workers do not want them to do, even though it's a very human reaction. And that we had a mental health clinic where we went to the state mental hospital and helped people there with their petitions to be released. And so it just got you in tune with the world of human reality and tragedies all out there up and down the line. So the Yale of big law, I was never really a part of that, but had plenty of friends who were, and it was just a good place that had a lot of intellectual ferment of all sorts.
Well, what I find really interesting, Pat, is you did work sort of exposing the problem of medical malpractice before you ever went to law school. I believe you wrote a book. I don't know the exact timing of your book, but you wrote a book called The Life You Save: 9 Steps to Finding the Best Medical Care and Avoiding the Worst. And I believe I mentioned in your introduction that you were a finalist for a Pulitzer Prize regarding, I think the title was Bad Doctors was the subject. Tell us about that.
So, so that was the book. The Life You Save is more recent. That was about 10, 12 years ago, and it was all about trying to teach people how to get better health care. I came up with a bunch of stuff, but my rule number one was to get your own medical records and read them, because you find out stuff about yourself, you find out stuff about your doctor, and you find out sometimes that they've just made mistakes about you, or there are things about you in there that you didn't even know. So I always advocate that anybody who has any kind of health condition at all, which pretty much we all do, should get and read your own medical records. The Pulitzer Prize runner-up thing, that was a long time ago. That was back at the Miami Herald, and that was about a problem that persists today in the world of medicine. In fact, we just had a blog post on my weekly blog about this subject, which is the state boards of medicine, the licensing bodies for doctors, have always been and seemingly still are very scattershot in their enforcement of rules of ordinary conduct on doctors. When we did our series back 1979, it was really bad. There was just this ethos among the members of the medical board, who were all doctors themselves, when a fellow doctor, a miscreant, would come up to them for discipline, their ethos was one of there, but for the grace of God go I, and I'm so sympathetic to this poor man who he's been through a lot, and it was just so bizarre, the lack of empathy for patients who were hurt by these bad actors. And we had some that were just absolutely hair-raising. A guy who had a patient in the hospital for multiple trauma, and checking her out of the hospital and taking her to a place and sexually assaulting her, for example.
Gosh.
And he had kind of a slap on the wrist penalty. So we were able to shine some sunshine on that, and it embarrassed them so much that they kind of went in the opposite direction and became really draconian, at least for a little while. This was state of Florida. I think since then it's the pendulum has swung again multiple times. But that was a big issue of professional self-discipline. As you know, Lloyd, in the world of medical malpractice, not often, but sometimes we come across these repeat offenders who seem to be able to just go on and do their thing and hurt people and never get called to account by the licensing boards. It's a real puzzle.
It's a puzzle, and it's it's infuriating. I mean, there's so many examples. There's another podcast I enjoy listening to a lot called is the Dr. Death series. You're probably familiar with it.
That was about this guy in Texas. Yeah,
out in Texas, and of course, Texas seems to attract doctors with spotty backgrounds because they've instituted so much so-called tort reform, which is basically immunity for the healthcare professionals by restricting patients' rights to get full verdicts, full access. And just an example of the system protecting bad doctors. And they'd have complaint after complaint, and then he would go off to a different hospital group and wash, rinse, and repeat. And it's a real problem. And you make some good points about that. I want to take a moment to acknowledge that this episode of Face the Jury is brought to you by our friends at Hughesby Reporting, the nationwide leader in court reporting, videography, and trial services. I have been working with Hughesby for a number of years, and the things that I like best about them are they are incredibly reliable, they have high-quality court reporters, and their post-production is just excellent. They get the transcripts to us on time. They're very diligent with the exhibits and making sure they're properly organized. And when you're taking a deposition, and as many depositions as we take at Bell Law Firm, that reliability is critical. And we are very pleased to have them as our sponsors. And I would encourage any trial lawyers out there or defense lawyers who want that reliability and that level of service to contact our friends at Hughesby and visit them at hughesby.com. That's HUSEBY.com. A lot of the folks that I know who listen to this podcast, a lot of my friends and colleagues and trial lawyers would be very interested in hearing from you about your greatest courtroom success, and not necessarily the highest dollar figure. There are a lot of those, but what's a case that you sort of look back on with pride, either because it was unwinnable and you won it, or the outcome changed your life in a profound way that touched you? Is there a case that's sort of comes to mind when you look back on all the trials you've had, and what maybe was the most impactful to you personally?
I was actually just joking to myself. You mentioned winning an unwinnable case. Actually, I've lost an unlosable case.
Oh, no.
So,
that's my next question. We're going to get to the tougher question in a minute, but let's start with the positive.
Yeah, let's start with the positive. I guess the most recent jury trial I had, which Actually, it's been a while since we haven't had any jury trials since the pandemic started, but I represented a little girl who suffered a very bad chemical burn when she was about, 2 weeks old.
Oh my gosh.
And she was in the newborn intensive care at one of our local hospitals here in DC, actually Georgetown Hospital, pretty prestigious hospital. And she had been born about 8 weeks prematurely. Did not have any super big health problems, but was being fed through an intravenous line that was hooked up to her ankle. And Rachel was, not a super tiny little thing, but she was still premature and only weighed a few pounds. And the problem with these IV lines is that the tip of the IV is supposed to go into the blood vein. Then the stuff that's coming through it, in this case, various kind of nutrients, including proteins and bodybuilding stuff that we all need, because she was too young to suck and to swallow. So the nutrients are supposed to go into the blood vein and then circulate throughout the body, which dilutes them, and then they get absorbed. Well, the problem is that little tiny babies, as we all know, tend to move and kick and stuff like that, and the tip can get dislodged. And if it goes into the soft tissue, right, like the muscle or the fat right next door to the blood vessel, it is very caustic. And if you don't catch it in time, it can cause a very bad internal burn, a chemical burn. And it's called extravasation is the fancy term for it. So Rachel had this. It was actually discovered by her grandmother coming in on visiting hours and seeing her across the room in the bassinet and thinking, why does she have a red sock on her foot? And then going up to the bassinet and seeing it's not a sock. Her entire foot and ankle are inflamed because this has gone on for at least an hour. And the nurse, she yells, and the nurse comes running up, and all heck breaks loose. And they do eventually get her stabilized. I actually didn't meet with the family for another, probably 9 months later. And she had recovered. She'd left the hospital. But she had the development of a pretty ugly scar wrapping around her ankle that made it look kind of shriveled, because what it did was it ate away the fat pad below the skin. And once you eat that away, the body cannot replace it in the ordinary course. And I remember thinking when I first saw her, it didn't look all that bad. But over the course of the next few years, as we developed the case, and then we got up to the point of trial, the trial occurred when she was 5 years old. Not only was it super obvious when you saw her, but she had also developed some problems with that leg on her, the right leg, where the ankle was, not growing as fast as the other leg because the injury had interfered with what they call the growth plate, which is the bone growth at there's one on each end of the shin bone, the tibia, and down at the ankle, hers just wasn't growing as fast as the others. So she was growing lopsided, and she was starting to be a little lopsided in her walking, and she was also a little stiff in her walking because the scar tissue around the ankle was tight. most of us take for granted that our skin is kind of nice and elastic and loose. Well, if you get a scar, not only is it ugly, but it's stiff, it's tight, and it doesn't move normally. And so this kind of restricted her normal ankle movement. And, as a little kid, she was pretty good at covering it up. What she would do that I noticed in watching her carefully, and her parents, of course, would talk to me about this, is she would skip. She would skip down the street like a happy little child. Well, it helped cover up the fact that she wasn't walking normally.
Wow.
So something that looked charming, but was actually a little bit of a coping mechanism.
And they actually took this case to trial?
Well, it's funny you say that. We were honestly talking to them about settling the case. We wanted a number kind of in high six figures. There's no damage cap in DC, but we didn't have hardly anything in the way of what they call special damages, the medical bills and whatnot. We could have blackboarded some 5 figures worth of both the past medical bills and maybe some future bills. She had laser treatments for the tightness of the scar. What they do is they take a very fine laser beam and they drill or burn hundreds of tiny little holes into the skin, which breaks up the hardness of the scar tissue and makes it a little more supple. But she'd already had 10 of those by the time of trial, and really wasn't all that helpful. But in any event, the defense, and thank goodness for us, we get to try cases where they make a mistake of judgment, typically. And they ultimately, by the time of trial, it was a no offer situation. We probably could have gotten maybe $500,000 tops out of them. And the jury wound up coming back with what I thought was a pretty darn good verdict, but also a verdict that I could look the judge in the eye and say, this is not an excessive verdict, because that was their motion after trial. The verdict was $3.6 million. And
that's a wonderful verdict.
Yeah. This is not a inner circle of advocates kind of mega number, but I was pretty happy with it. And the defense filed a post-trial motion saying, "Oh my God, Your Honor, this is the biggest extravasation IV infiltration verdict that has ever been put out in the history of mankind. And you have to, reduce this."
I can hear the argument in my head right now.
Yeah, so the key thing I learned on that motion, and this is kind of getting into the weeds of trial work, if you get a good verdict and you have to defend it on a motion for remitted, motion to reduce, do not fall into the mistake of doing comparative verdicts. Maybe you've got the biggest verdict out there, maybe you don't. But when you start comparing apples, you're always comparing apples to oranges. Every verdict is unique and should be defended on its own merits. And that's what we did in this case. In fact, I found there's good case law, by the way. New Jersey Supreme Court has a case where they squarely said the judge should not do verdict comparisons for that very reason. You can never find out enough about the other cases that you're trying to compare compared to your own, and your own needs to either stand or fall on its own merits.
Yeah, you make a great point, Pat, that I want to spend a moment on, because you're right. I mean, every case is unique because every person is unique, and a person who has a finger injury, for example, is a construction worker. Maybe it doesn't impact their ability to do their job or even their life. But if you're a concert pianist, for example, it's a catastrophic
Yeah.
injury. And the piece that drives me nuts is I'll hear some of my colleagues uh, get sucked into this defense trap of looking at verdict reporters and making their judgments on what their case is worth based on these published verdict reporters. And they're companies that make a lot of money compiling plaintiff's verdicts or and defense verdicts. And then you look and you sort of look at the facts and, oh, I have a case that involves extravasation or stroke or whatever it might be. And you start thinking, well, they only got this much. My case isn't. And it's corrupt thinking because your case is your case, and your case may be worth more or less than these other ones, but it's your case, and you can't take a shortcut by looking at a reference book on what your case is worth. That has to come from developing the story. And yeah.
I totally agree with you, Lloyd. And, it's a favorite topic of the listservs. I'm sure you're on a lot of these as well as I am. I practice in not only District of Columbia, but Maryland and Virginia, our two adjoining states. It's a frequent inquiry. What's it worth on the listserv? And, in fairness, it's not a horrible question. I mean, there is kind of a range that you can get for particular types of injuries. And there are some that sort of lend themselves to that. There's a emergency medicine frequent issue with a little boy will come in with severe pain in their testicles, and it turns out that it's twisted the blood vessel, and they wind up losing a testicle. Well, what's that worth? Okay, yeah, there is a history there, and maybe it works for that kind of case. But in most cases, I would say it's different, and the value, quote unquote, of the case, a lot of it also depends on the moral worthiness of your people. In this a baby case for Rachel, our client, I still remember in the closing argument, one thing I was able to do on the moral worthiness front that we actually kind of fell into, which was I was able to disclaim and say to the jury in the closing statement, you notice, ladies and gentlemen, that on this list of the damages that the judge has read you about the different categories that we can claim, there is not a category for the medical bills that the parents have incurred. And all those trips they made up to Johns Hopkins Hospital, the 10 or 12 trips, and staying overnight while their daughter got these laser treatments, they're not asking for a dime for any of that, or for their bills, or for anything for themselves. This is all about Rachel, and all of the money will go to her and to a special account that will be preserved for her. And when I explained that, at least one of the jurors nodded and looked over at the parents in a very admiring kind of way. So you're if you can play that card of the selflessness of one or more of your clients, it really is quite helpful. And I say we fell into it because it was kind of funny. When we first filed the case, we actually filed it with a claim for the parents of negligent infliction of emotional distress. And it's an undecided question under DC law because we used to have, for negligent emotional distress, you used to have to be in the zone of danger, so to speak. In other words, if you were standing at the traffic light and it turns, the walk light comes on, but a speeding car comes through and almost hits you, but not quite, you could have a negligent emotional distress claim. but that expanded with a case that the D.C. Court of Appeals decided en banc, where they said that if there's a special relationship between the defendant and the plaintiff, where the defendant was required to watch out for the plaintiff's mental and emotional health, then you could have a claim. The classic example where they said you could have a valid claim is the claim against the funeral home, where the widow comes in right before the funeral, and they open up the casket to show her deceased husband, and it turns out they mixed up the caskets and it's the wrong person.
Ugh.
And the horror of seeing that and the emotional distress. There was actually an old DC case that said, sorry, she wasn't in the zone of danger, no case. But in this new case, which was actually a healthcare case of a misdiagnosis of AIDS, they told a guy he had AIDS, and he really didn't, because he'd only had the preliminary screening test and not the full-blown test. So he thought he had a fatal disease for 5 or 6 years until finally found out he couldn't. In any event, they expanded the rule to say that if the defendant owed you a duty of emotional care, then you could have a claim for negligent emotional distress. So we said, hey, in the newborn intensive care unit, they actually say in the defendant, the hospital, they say, we have 2 patients. We not only have the baby patient, but we are treating the parents as well. So we thought that was a pretty good claim.
What the judge think?
But the trial judge did not think so.
Okay.
And actually, about a year before trial, they filed a motion to dismiss that or summary judgment, and we lost. So by the time of trial, we really had nothing except the medical bills, and we could easily let those go to make it a pure case. The beauty was post-trial that we had the only real appealable issue, which was the denial of our claim for the parents for negligent emotional distress. So that was kind of fun.
Were you able to use that appellate issue to get the case resolved?
Yeah, exactly. They wound up paying the full amount of the judgment for the little girl, and a confidential sum for the parents on the side.
Oh, that's great! Congratulations. Yeah. As you were telling your story, just the point crossed my mind about how the law doesn't stay still, and these rules don't stay still, and the interpretation of the law doesn't stay still. And good lawyers, creative lawyers like yourself, thinking of ways to advance your client's case and pushing on the fringe, and not necessarily the fringe, but pushing case law beyond where it's been previously is a really important role that we play. To always be thinking of how can the law, because the law is meant to serve our clients. It's not meant to be this monolithic, impenetrable structure. So that's just another example of great lawyering. I appreciate you sharing that. We've covered a lot of ground today with our friend Pat Malone, but there is still so much more to talk about, and we've had the pleasure of discussing some of his personal hobbies and how they apply to trial law, and some of his philosophies for being successful in the courtroom. So please join us next time as we continue our conversation with the GOAT, the greatest of all time of patient safety and patient advocacy, our friend Pat Malone.